Good day, my name is Thomas Minnie and I'm a senior practicing attorney at Thomas Minnie Attorneys in Pretoria. Today's broadcast relates to a provision in the Constitution of the Republic of South Africa, namely Section 36, also known as the Limitation Clause. Now, the reason for this broadcast has been prompted twofold, namely that I have read on social media and the media in general, as well as addressing the constitutionality of certain of the regulations, whether it be the regulations that were published during the initial lockdown or the subsequent regulations. Please keep in mind that the aim of these broadcasts are not to turn everybody into attorneys and advocates, but simply to inform the public and allow the public to make informed decisions regarding certain aspects that have become relevant during this lockdown period. Now, in order to understand the mechanism of Section 36, I am going to read the relevant provision from the Constitution, and then we're going to go into a brief discussion. The limitation of rights, Section 36, reads as follows. The rights in the Bill of Rights may be limited only in terms of law of general application, to the extent that the limitation is reasonable and justifiable in an open and democratic society based on human dignity, equality, and freedom, taking into account all relevant factors including A. the nature of the right, B. the importance of the purpose of the limitation, C. the nature and extent of the limitation, D. the relationship between the limitation and its purpose, and E. less restrictive means to achieve the purpose. Then subsection 2 states, except as provided in subsection 1 or any other provision of the Constitution, no law may limit any right entrenched in the Bill of Rights. So just before we get into the discussion regarding the application of Section 36 of the Constitution of the Republic of South Africa, I just want to draw your attention to 2 or 3 court cases that have already taken place in the Gauteng province. There has recently been an application brought on an urgent basis. The case briefly dealt with the right contained in the Bill of Rights, namely the freedom of religion. The facts briefly are that a Muslim person brought the application on the basis that it unfairly discriminated and limited his rights to practice his freedom of religion in the way that he had prior to the regulations. The High Court in Johannesburg disagreed and the application was dismissed. Now, the importance of that application is that we can already see that the courts find, or that the court found in that case, that although there might have been a limitation of the right to religion, that limitation was justifiable. I can also mention that in another matter heard in Pretoria, in the North Gauteng High Court, the issue relating specifically to the tourism industry was brought on an urgent basis. For purposes of this discussion, it's unnecessary to disclose who the parties were, and I can tell you that that matter has now been referred or is going to be referred to the Constitutional Court for further adjudication. And in that matter, the High Court ruled that the alleged discriminatory basis for those companies seeking relief was not material and therefore did not amount to a discrimination. We will, however, wait to and see what the Constitutional Court decides regarding that matter. Okay, so then looking at the application of Section 36, the first thing to remember is that Only Section 36 and any other provision as may be contained in the Constitution may limit your rights as contained in the Bill of Rights. Now, when the test is conducted on whether your rights have been infringed upon or not, the two-stage approach relates to the procedural as well as the substantive stages. Now, in the procedural stage, there are certain questions that are answered by the court to determine whether the court has jurisdiction to proceed with the matter. For purposes of this discussion, that is not relevant. Stage 2 relates to the substantive component of the inquiry. Now, it is during that substantive stage that both the limitation as well as the interpretation of the specific law is analyzed. For purposes of this discussion, that is where we will be focusing. Now, you will recall when I read the provision, Section 36, was that the law to which the limitation relates, or to which the dispute relates for that matter, must be law of general application. Now, it is in this term where the members of the public seem to have the biggest issue. Now, certain members of the public are of the view that it is these regulations in their form as law of general application that will not stand the test of constitutional scrutiny. In that, when having a look at the regulations, these regulations indirectly discriminate against them due to the fact that they are either smokers or enjoy consuming alcohol. There are also those that are of the view that the right to life as well as the freedom of movement also remains a right which has been infringed upon and will not stand the test of being reasonable and justifiable in an open and democratic society. I wish to make it abundantly clear that the aim of this broadcast, in respect of Section 36 and you as members of the public, is not to convince you one way or the other. It is to allow you as a member of the public in the Republic of South Africa to make informed decisions regarding your rights and to decide whether your specific circumstances warrants the further intervention by a legal practitioner. It may also make you think twice before you push the button on that next social media post or make some comment on your WhatsApp group. If this broadcast has succeeded in tweaking that interest, my suggestion is, while you have time on your hands, take the Constitution and read Section 36. And then before making a decision, consider whether you believe that there is a less restrictive method in obtaining the purpose of the various limitations which have been placed on members of society in order to achieve the aims and goals of government. Please note that should you be of the view that your specific circumstances warrants further legal intervention, then you should contact your local legal practitioner. You may also contact me. My details will follow after this broadcast. As a final thought, consider the following. Hope planted in the fertile soil of positivity will surely only harvest vision and determination. Be safe and God bless.